Man, it has been a busy January.
A very busy January for us, at least.
Yeah, for us. I think it's because, lawyers and judges alike, they don't want to schedule anything over the holidays. So everything gets kicked to January.
Right.
It seems fine in December, but then you get to January and you're like, uh-oh.
Yeah.
So yeah, we've been going nonstop the last few Fridays, just mediations and depositions and who knows what else.
I was actually excited though today when I came in. I was like, oh, we're going to be able to do a live today. So
Yeah.
I'm starting to enjoy this experience.
Yeah, it's nice. Yeah. And we're getting a lot of good comments, seem to be getting good feedback.
Yeah,
So we'll just keep doing it.
absolutely.
Um, Attorney's fees.
Oh, yes.
I think we need to talk about it again.
It's a painful conversation.
It is, yeah. And I get why. I mean, you come into a situation, especially as a beneficiary, we tend to represent beneficiaries. You're being abused. You got to hire lawyers to take care of stuff, and then you have to pay for them, and you end up walking away with less than what you should have gotten under the whatever will trust that you're fighting for.
It's a very frustrating experience because let's say you have a right to $2 million. Trust document says it in typed written language. It's signed, sealed, and delivered. You're supposed to get $2 million, and for some reason, the trustee or some other beneficiary or heir comes out of nowhere and says, "Oh, I think you're not entitled to that for X, Y, and Z," and then you have to hire a lawyer, and it says right there you're supposed to get $2 million. So what does the client say?
Yeah, are they going to pay for my attorney's fees?
And are they going to pay me my $2 million?
Yeah, and the answer is no.
No to both of those?
Yeah, no to both of those.
How can that be possible? It says it right there in black and white. I'm supposed to get $2 million.
Yeah, and it's such I mean, the hardest part about this conversation is that at least conceptually, just based on common sense as a fellow citizen, I agree. It makes no sense.
Right.
And yet this is the way it works. So the American system, everybody pays their own attorney's fees, whether you win, lose, or draw.
Let's talk about that just for a second. I don't want you to lose where you're going there, but when I have to hire a lawyer to get my $2 million, you're telling me that the way it works in California and the United States generally is that I have to pay my own attorney's fees even if I win.
Right.
Do I have to pay the other side's attorney's fees ever?
No, well, typically no. I wouldn't say ever, but typically no. They have to pay their fees. You have to pay your fees.
Okay, so if my fees are $200,000 for my lawyers, and I have a $2 million gift that I'm supposed to get, let's say I get all $2 million. I know I'm not going to because you're going to talk about that in a second, but I get all $2 million. I'm only good by 1.8 million. How come who makes the wrong right for me that I had to pay $200,000 for lawyers?
Who makes the wrong right? I guess nobody, because the law says that you have the right to go to court. You have the right to pursue the money that you're entitled to. And you further have the right to pay your attorneys to do that. And nobody's going to pay you back for that.
So I have to pay my own attorneys. That's an insult to me. I just want you to know I have to pay $200,000 of my $2 million that I'm supposed to get under the trust. But then you make it worse, Keith, because you just told me I'm not going to get my $2 million either. So what are you talking about there?
Well, that's because most cases are going to settle. And when you settle, you're going to have to compromise, which means you're going to take less than what's in the document. And the reason why people take less is because there's a risk of loss. And you have to figure, well, what is that risk of loss? Do you have a 100% chance of winning come time of trial? And the answer in 99.99% of cases is no. You do not have a 100% chance of winning. There's a scenario where you're going to lose. And sometimes you're going to lose 3 times out of 10. Sometimes it's 4 times out of 10. Sometimes it's 6 times out of 10. You have to take that into account. And the reason why you have to take that into account is because the lawyers on the other side are taking it into account too. Just as we do when we're, defending versus bringing a lawsuit, we're taking it into account. So the great thing about settling and mediation is that you get finality. You get a known result right now, money in hand, end of story, no more risk. So you shut down that risk. But you're not going to be able to do that for 100%. You're not going to get every dollar on the dollar that you're owed. You're going to have to take something less than that, if that makes sense.
It does, and to me, you've been talking about the risk of loss, and that is
Yeah.
you could go to trial 3 years from now, and you could actually lose and get nothing. That's what you're talking about there. I think the other aspect that gets settlements done, and the reason you take less, is because of the time, just the pure time it's going to take to go from where we're at today to a successful result that we're not guaranteed, because you're talking about that risk of loss. We could go to trial 3 years from now on a very good set of facts and we could lose. It's not likely, but we could lose. The real thing for me, though, is when we're representing people is explaining, look, it's going to be 3 years to get to trial. And then after trial, there's going to be an appeal
Yeah.
inevitably by whoever the losing side is.
At 2.5 years.
And that'll go another 2.5, 3 years. And the worst part of that is many times the appellate court won't even make a final determination. They'll simply send the issue back to the trial court to retry it under whatever standard the appellate court has looked at. And so you got 6 years that you've got somebody that's going to fight, and you are not sure you're going to win. You think you're going to win, but you're not sure you're going to win. And that's why today at mediation, you'll take less and you'll suffer your attorney's fees. Is that right?
Yeah, that's right. And then there's the costs. So as you get closer to trial, you're hiring expert witnesses, you're taking treating physicians' depositions. I mean, all of those things go into the mix. And so you're going to pay 100,000, 200,000, 300,000 more in costs.
If we have to hire a expert forensic physician to go through medical records and opine on capacity and susceptibility undue influence, how much do we have to pay for that?
Oh gosh. I mean, it's $20,000 just to get a doctor to look at the records. That's just the starting point. And then it's going to cost you another $25,000 to $50,000 to get them through deposition. And then it's going to cost another $25,000 to $50,000 to get them through trial testimony. And that's for one witness.
100 grand.
Easy for one, maybe more.
And if we have to have more than one doctor,
Which a lot of times you do.
and then you have to have probably a lawyer that opines on standard of care
And maybe a financial expert on the finances. I mean, you can rack up hundreds of thousands of dollars on experts just like that. It's so crazy how quickly it'll go. And the timing thing's a real deal. I think we talked on this podcast about an appellate court decision under Key versus Tyler, I think it was. There's a case that has like 4 different appellate decisions on that same case. The case has been going on for like 10 or 12 years.
Yeah.
I mean, that's a worst case scenario, but geez,
Yeah.
unbelievable.
Yeah. So all this to say, it's unfair that people have to pay attorney's fees, although that's probably true of any case, not just trust and estate. I mean, personal injury, contract, constitutional law. If you're going to stand up for your rights, you're going to have to hire somebody to do that in most cases.
Personal injury is a good example,
Right.
where, you're harmed. Let's
Mhm.
say because of your harms, you're entitled to $2 million,
Right.
but you have to pay your attorney 40%. You don't get attorney's fees there either.
Well, but the same, and I guess if you think you're entitled to $2 million because you lost your arm, let's just say your arm is worth $2 million. Are you still going to settle that for less than $2 million at mediation?
Oh yeah. I mean, you have to compromise, of course. And so, but even if you got a settlement, 2 million, you're going to lose 40% of it to the attorney who brought the case.
Right.
And there are no attorney's fees for torts by and large.
Right.
I mean, you're not going to get your attorney's fees from the other side. So yeah, it's a tough situation. I think part of the problem is you have to look at it as, if you want to kind of redirect your thought processes, you weren't given a $2 million gift. You were given a gift that comes with problems. And it kind of, we were talking about this before, and it kind of reminds me of if I gave you the gift of a house that's worth 2 million, but there's a $500,000 mortgage. Okay, well, you're not really getting 2 million because there's a mortgage of 500,000.
Right. It comes inherent with the property.
It's inherent in the property, right? And so you think you're getting a $2 million gift on paper. That's what it says, but it really isn't, because somebody is handing you a problem. That's what they're handing you. And so you're going to have to deal with that problem.
I'd be okay with somebody handing me that problem.
If you end up netting some money, yeah, of course.
Yeah.
But it is frustrating, and I don't blame people for getting frustrated about it.
So one of our favorite authors, is it Nicholas Taleb, that wrote Black Swan and a few of these other fantastic books that
Tassim. Taleb.
Anyway, it's
Yeah.
Taleb. And he talks about, somebody that thinks they're going to get $2 million and they think they're going to get 2 million. And that's why they're so disappointed when they only get $1 million or $1.2 million or whatever it is. What's going on there in somebody's mind?
Oh yeah, the psychology of it's so
Yeah.
interesting. So if you start at 0, but you got $1 million,
I'm rich.
and you walk away with $1 million, you'd be very happy.
Right.
But if you start at 0 and you go to 2 million, but somebody takes $1 million away and you walk away with $1 million, you're
Yeah.
disappointed. But both results are the same. On
Right.
both scenarios, you're walking away with $1 million. There's no difference.
Right.
But it's the mentality and the psychology of going from 0 to $1 million versus going 0, 2 million, down $1 million. that's what is very disappointing psychologically for people. Interesting.
Yep.
Yeah, that was all in Anti-Fragile. If you ever want to read some fascinating series of books, the Anti-Fragile books by, I thought it was Nassim Taleb.
That's what it is, Nassim Taleb.
And yeah, those were really good. So that's our bid on attorney's fees. Have you been looking at any of the Blake Lively, Justin Baldoni, Dino, whatever?
Only I'm seeing that they're both ratcheting it up and accusations are flying. But I think you know a little bit more about it than I do.
Well, I've been trying to. I've been like reading as many articles as I can, and I'm still just as confused as I ever was, because for every bit of information and texts and videos coming out on one side, there seems to be an equal amount coming out on the other side. And then Blake Lively's attorneys filed for a gag order on Justin Baldoni's case in New York. Baldoni, thank you. And everybody's up in arms because I look at these comments, and our friend Zach Peters, is it?
Yeah, Zach Peter.
Yeah.
Yep.
Zach Peter, we were on his podcast. He's the guy that really keeps up with this stuff. If you really want the up to the minute information, he's the guy, and he's entertaining to listen to. But a lot of comments on his podcast, everybody was up in arms that somebody would try to put out a gag order to stop Justin from being able to defend himself. But I was kind of laughing about it because it's like, well, but that's just what lawyers do, right? I mean, we would just, we're going to do a gag order to protect the jury pool or whatever. Lawyers don't necessarily think in PR terms, I don't think, when it comes to stuff like that.
Yeah. Yeah.
So, but I did read an interesting article about how, this is something we could talk to, how is this case going to end? And so, basically it's going to end by, it either goes to trial and one side wins, or there's going to be some sort of settlement before it goes to trial. Well, you and I know that 95% chance it's going to settle.
99%.
It's going to settle.
There are people out there that think only 95% of cases settle, but it's 99.
It's pretty high.
Don't hold yourself to 95 when it's 99.
Well,
but anyway,
sure. I mean,
that's my 2 cents. So.
There's a high degree of likelihood that's going to settle. And then when it does settle, it's so disappointing.
I win 95% of my cases.
Yeah, so does everybody else.
But 99% of them settle. So.
It's not whether you say you win, it's what the result is that matters.
That's
right?
true. That's very true.
Yeah.
Yes.
So,
Yes.
if I win $1 95% of the time, I can
Yes.
still say I win.
Yes.
But what do you think? I mean, how does a mess like this end?
Well, right now you got mutually assured destruction that's going on both sides. They're
Yeah.
both tarring and feathering each other. They're both tearing each other down. It'll take years for both of them to rebuild their reputations. At some point, somebody's going to say, uncle. Egos are involved. These are very emotional decisions that are going on. I know that Ryan Reynolds has been sued as well. So I'm sure he's angry. He's worth a couple $2 billion or something. He sold, he made money in acting, but he really made money in telecoms or something like that. It was some green mobile or something.
Right. Yeah. I made a fortune.
But he did all right. But so he's involved. So, somebody's going to have to pull these parties together and say, look, we're killing each other here. And the only people that are winning are TMZ and the likes of TMZ. So how do we resolve this? And then, we all need to go away for a year, and then we can come back and slowly rebuild who we are in front of the public eye.
Yeah. Yeah. Such a mess.
Yeah.
But so disappointing when they settle because nobody admits liability, and then they probably have a confidentiality order or something. So it's like, I want somebody to be responsible.
Yeah, no, it's typical. Yeah, they'll settle more than likely. I mean, it's going to cost too much in money and reputation to take this all the way. I mean, it could go to trial, but the chances are very, very low.
Yeah. Yeah. Very low. What do you think?
Producer Eric, how are you doing? We just been blathering on over here.
No, it's great. I love it. Yeah, I'm doing good. Thank you guys. Best part of my week. Not just because it's Friday afternoon, but
Are you thinking about the weekend when you're supposed to be at work, Eric?
Nope.
I want you only thinking about work, okay? You can't think about the weekend.
That's my brain. I got content brain all the time. But yeah, let's get to some of the questions that we had gathered. By the way, I feel like we need a nickname for the listeners of Ask Two Lawyers. So I don't know if anyone can think of something.
Ooh, that'd
the
be good.
Askies, who knows?
The Askies
something like that.
sound so great.
Come again?
Yeah, what'd you call me?
Yeah, right. Yeah. Those are fighting words where I come from.
But we had a question come in. I thought this was interesting. A listener wrote and said, how reliable is it to serve a petition for accounting and distribution to a trustee at their home address by mail? Can the trustee claim they never received it?
I mean, they can claim whatever they want, and it doesn't really matter how reliable it is. The code says that's how you serve that type of petition is by mail to the last known address. And if they claim they didn't receive it, the court's going to issue orders on the petition anyway. And so either the trustee has to show up and object to whatever it is you're trying to do, or they don't show up and object, and then the court can rule without them.
Yep.
So I mean, there's really, I wouldn't stress over it. The code says mail it, you mail it.
Yep. One thing I'll say about notice and service, we tend to overdo it here, and that's just because we want. Thank you, Casey Colby. We're glad to see you. Welcome back in. We normally serve by mail, email, smoke signal, and the reason we want to do that is we want to be able to tell a judge when somebody shows up and says, well, I never got that at my mailing address. Well, we sent it to your lawyer. We sent it to your email that we had. We sent it to your lawyer's email. We want to make sure the judge knows that they at least had it. But you're technically correct. We have to follow the code, and the code says by mail or personal, depending on what kind of case it is.
Yeah, if the trustee shows up in front of the judge and says, Your Honor, I never got this to my post office, the judge is going to say, well, you're here now.
Yeah.
Welcome to the party.
Yep.
I thought it was interesting, and you kind of brought up the point is, and I've heard you guys talk about, process servers and things like that, and that is something that I feel like is sort of like the movies. I know everything is not you can't handle the truth sort of stuff, but the process server stuff is interesting to me too.
And there are times when we do have to personally serve certain types of lawsuits or types of claims. And there can be, some people can be good at evading service, but we get them eventually.
You always get service. I mean, this evading service stuff, like we have a lawyer right now that we're going against that thinks he's going to play it cute, I guess. And he told us to send over the notice of acknowledgement so he could accept service on behalf of his clients. And so we went ahead and served him with the lawsuit, and we served him 2 or 3 times because he just simply won't get back to us.
Right.
So we're going to in fact, we personally served one of his clients, and we'll personally serve the other.
Yeah, we'll get him.
And we'll get him. So, I mean, we can play these games if you want to, but it's not showing how tough you are by simply refusing to provide back a notice of acknowledgement that you asked us to send you.
Right.
So it's not a good way to start off the case.
No.
Have you ever had to use someone that's like a super professional, disguises sort of thing?
So we were just talking about this the other day, and I had a guy that I used to use back in the day, and he would dress up as a FedEx delivery guy. He had a UPS and a FedEx suit. I don't know where he got them from. And he said he served so many people that way. It was amazing. So, but he would hide under cars. He told me he would hide in bushes and jump out and serve somebody. I mean, it's just crazy stuff. So, yeah.
That's great. Okay, next up, and you guys have talked about this being sort of a fool's errand in the past, but someone wrote in to say, what advice would you give to someone who must self-represent due to having a modest share of the trust?
I mean, it's tough. It depends on what you're doing. So if, for example, you're going in to try and, demand a distribution from you want the court to order the trustee to distribute, you should be able to find something online that you could file, and you could probably show up in court. So if it's something fairly simple like that, I think you could, handle it. If you're talking about like an accounting, you want to go in and litigate an accounting issues. Oh boy, that's tough without a lawyer. I mean, those are some of the toughest cases we handle as lawyers. So I would say it kind of depends on what it is you're up to.
Yeah, I don't think that you should ever represent yourself. Keith and I, you and I've had issues through the years where we've had to hire lawyers. It's never fun. Well, I shouldn't say that. It is fun sometimes. But we hire people because, number one, they're not as emotionally connected to the case as we are, and they can handle the issues for us. And that's the idea of having a lawyer. And it's almost like, a neurosurgeon. Should a neurosurgeon do neurosurgery on oneself? They're perfectly qualified to do so.
Right.
But it would be challenging, right?
Yeah.
And so can they do neurosurgery on anybody else? Yeah, sure. Great. Wonderful. Do that. But I personally, if I had a trust matter, I would not handle it myself. I would turn it over. And I know trust, but I would just turn it over to somebody else and let them handle it. So I hope that answers your question. Even though it's a modest amount and it's always frustrating to pay attorney's fees, something we've already talked about today.
Yeah.
If you can figure out how to get representation, you should do it.
Yeah.
I want to get to this one by Casey Colby here. They write in to say, just told by trustee's lawyer that unless I sign release, no distribution, Can't afford a lawyer right now. That's why I asked for partial distribution. Do I have to wait until I get notified of petition for court approved accounting to object? But can I petition before partial distribution? I'm not sure if that's clear to you guys, but maybe you
Um,
could lend a hand.
I think it's clear enough. I mean, you definitely can go to court and petition for a partial distribution. You don't have to wait for a petition for an accounting to do that. It's just a petition for instructions that you'd be bringing. And you can ask the court to order a partial distribution. I'm glad to see that you didn't sign a release. Casey, that was a good decision. Don't ever sign a release unless you absolutely know what you're doing and you have full disclosure. So that's, that's a good sign. But yeah, you can go to court now.
Okay, thank you. Here's the next question we had gathered. This is sort of a two-parter, but how to handle a hostile trustee who refuses to follow trust terms for a beneficiary who is free of trust. The trustee believes she has discretion over distributions to this beneficiary, like other beneficiaries who have guidelines in terms of distributions. The trustee lawyer told this beneficiary that all disbursements are discretionary, even though that beneficiary is outright and free of trust. So maybe what does free of trust mean in the first place?
Free of trust just means that you get your assets distributed to you. Free of trust means there's no longer a trust for you. So there's two ways to make a distribution to a beneficiary. You can put it in a continuing trust. So I could say I leave assets to my sons, but they're going to be held in trust, and their assets are going to be held in trust for a certain term of years or until they reach 40 or for their lifetime. Or I can just give it to them outright. And when you give money to people outright, trust lawyers call it outright and free of trust. There's no more trust. So we handle tons of these cases where a trustee just refuses to make a distribution. And we've had cases where trustees refuse to distribute for like what, 8-10 years? It's
Yeah,
crazy.
long time. Yep.
So then you just have to go to court on a petition to ask the court to order distribution. And sometimes you have to order sales of assets to fund distributions and, whatever it is you need to do. But it is very frustrating when we take on one of these cases where a trustee just absolutely refuses to make distributions when it's supposed to be outright and free of trust. I don't get it. I don't know why people get so stuck in their ways. And here it looks like the trustee has an attorney and still it's happening.
Yeah. Either somebody's wrong on whether it's outright or not, and maybe it is discretionary. But if it's outright, then they should be able to get it.
But we've had cases where attorneys have not advised trustees well, right?
Well, they advise them not to make distributions until they get a release. And of course, that you don't have to sign a release to get your rightful distribution. So it goes on and on.
Yeah, it's very frustrating. But yeah, the answer is you have to go to court and you have to get a court order.
All right, thank you guys. Here's another interesting kind of question that I wasn't sure on. I was looking into this in our Google Analytics, and it seems like people are clicking on our website with this, from this query, and that's what is a Heggstad petition?
Stuart?
So it comes from a case. I think it's a 1993 case, the state of Heggstad in California. And what the proposition originally stood for was where somebody would create a trust and they would include an exhibit A in the back of their trust. And it would include their real property, their house, and something else with a deed. But they'd never get around to actually changing the deed on the house from their own names into their trust name. They just have this exhibit A on the back of a trust that says, I hereby, give this trust my property. And so the issue there is you normally have to file a petition for probate on any assets that are outside of a trust after you die. And so with the Heggstad petition, the idea is you could just file a Heggstad petition under a state of Heggstad with the probate court and say, hey, they really meant to fund this to their trust. You can see that by this exhibit A they have in the back where they've listed their real property, but they never got around to formally transferring the real property by deed to the trust. Can we all just kind of wink at each other and agree that they meant this to be a trust asset? And can you, the court, simply order that this is a trust asset? And for the longest time, courts would welcome these Heggstad petitions, and we would transfer volumes of assets that didn't make it formally into a trust. We just transfer them via Heggstad. At some point, I think it started with Orange County, some of the courts, they just slowed down. I don't know if it's because they were missing out on administrative fees for probates or whatever the case may be. Maybe they just wanted to stick to the law closer because the Heggstads had gotten out of control. So now if an asset is outside of the trust, it's a much tougher a burden, or you have to rise to a standard much higher than just typically saying, well, they attached it in Exhibit A, therefore let's treat it like a trust asset.
Yeah. Yeah, exactly right. And it just stands for the proposition that if you are the owner of an asset, you can declare yourself to be trustee of that asset and hold it in trust without formally changing title. And there's another case that came out about 10, 12 years after Heggstad, Olmsted or whatever it was, that now it also applies not just to real property, but personal property like bank accounts and
Right.
such. So yeah, handy little case.
Yes, it works from time to time.
Yeah. We don't do a whole lot of Heggstads anymore, but back when we did estate planning and trust administration and all that, we did a lot more of that.
I did a lot of Heggstad petitions, and then I did a lot of safe harbor petitions on no contest
Oh my
clauses.
gosh, yes, safe. So there was, God, there's a time when you could file for safe harbor and ask the court, if I file this trust contest, will it be a trust contest?
Yes,
And get a declaratory relief. Oh yeah, the court found out real quick that was a mistake.
because every single trust that had a trust no contest clause, we were constantly filing a safe harbor every single time.
Then you're litigating the safe harbor and to get a decision, and then you file the trust contest. I mean,
Yes.
talk about adding time and expense and court resources. Oof.
So now you have to file your you have to file your trust contest and trigger the no contest clause, and just hope that you have what we call probable cause
Yeah.
to file that.
Right.
And then, of course, there are certain prongs of triggering a no contest clause that you're not allowed to look at probable cause, and it's simply a triggering event and you're out. So there's still some landmines out there with no contest clauses.
And I got a beef about probable cause. So a lot of times people call up and they're like, so probable cause is this concept that you will not be disinherited if you had a reasonable basis of thinking that you could prevail if given a chance to do further discovery.
Yes,
Loosey-goosey standard.
it's
right?
pretty loose.
And so people will say, well, the other side did this, that, and the other thing. I think it clearly is undue influence. Therefore, I have probable cause. Boom, end of story.
Right.
No, not end of story. That's, you don't get to decide that. Some judge 3, 4, 5, 10 years from now is going to decide that.
Right.
If you take your case forward and you lose.
Right.
So probable cause, I mean, filing the trust contest is a risk factor, even if you think you've got probable cause. And no lawyer worth their salt in this area can tell you if you have probable cause or not. We can say that you might, it's likely you have some facts that indicate that you should, but do you actually have it? I don't know. It's impossible to say.
Yeah. Yep.
So that's my pet peeve about probable cause.
Yep.
Okay, I wanted to read a couple headlines too while we're here, because I'm curious about what will happen in this. So this is a California lawyer who's also a Stanford law professor. Was the lawyer for Mark Zuckerberg, and now he's dropping Zuckerberg as a client, saying that Zuckerberg has descended into toxic masculinity and neo-Nazi madness. What typically, we don't have to get into that, but what typically happens if someone
Thanks for dropping that
Yeah.
bomb and walking out of the
Well,
room.
what happens when a lawyer would drop a client like this? Like, what does this tell you, or what kind of might happen?
Well, first of all, I think this lawyer's saying too much about dropping this client.
Yeah, you got to be careful.
I'm surprised why the lawyer feels comfortable enough to say those things, especially against somebody who has the resources to go after you. But who knows? I don't know all the facts, but you certainly can drop clients. Clients can fire lawyers. There's nothing wrong with that. But lawyers have to be careful. In fact, when we want out of a case and a client wants to force us to stay into a case, we have to file a motion to be relieved as counsel. And we have to be very careful with what we put in our declaration, because you can't disclose any attorney-client privileged information in those filings. And I've been in court, Keith. In fact, I think you were in court not too long ago. Well, I won't say the county court we were in. And a client stood up and was trying to get their client on Zoom, or their lawyer on Zoom, to stay on the case. And the lawyer went into all of the things that this person had told them. And it just went on and on and on. It disclosed all this attorney-client privilege. And I'm sitting there going, and the judge didn't say anything about it, but ooh, that's not a good thing.
No, yeah, you have to be real careful what you say. There's 2 reasons why, well, maybe 3 reasons why a lawyer drops a client. So one is, and what you'll see in the motion to be relieved, there's a breach of the engagement agreement. All right, that means they're not being paid.
Yeah.
That's what that means.
Right.
So if the lawyer's not being paid, they'll drop the client. The second one is if there's just a difference of opinion about how the case, there's just a strategy disagreement that you just can't get past. That'll be another one. And then the third one is if there's just the case is no good.
Yeah.
And so the lawyer's like, there's nothing here. This is a terrible case. And the client doesn't want to accept that
Right.
and wants to keep it going. And so those are the three main reasons why a lawyer will drop a client. But yeah, you never should say specifics, when you're trying to get out of a case.
If you're saying something about neo-Nazis or whatever, stop.
Yeah.
Just stop right there. Don't
Even
go.
if it's true.
Yeah.
I mean, you could have even seen the client go to like a Hitler youth rally or whatever. Just don't talk about it.
Yeah. What are some of the things that we can share with people? Never start a land war in Asia.
Never, never match wits with the Sicilian when death is on the line, and never mount a land war in Asia,
and never attack Russia during the winter.
Yes.
Never do a 2-front war in Europe. I mean, there's all kinds of little wisdoms that we can share.
Yeah, we should write a book.
Yes.
Let's get to this one. Casey says, so many different classifications for fraud. What if trustees lied on transfer deed to another beneficiary despite my disagreement for it was under FMV, and lied that all beneficiaries agree to convey property?
Well, that'd be an objection to the accounting. And so, as far as the fair market value, a judge is going to look at that and say, well, that may or may not be fraud. I mean, it could just be somebody's confused. They didn't get a good appraisal. It could be negligence. It doesn't necessarily have to be fraud. If they said all beneficiaries agree and you didn't agree, okay, well, maybe that could be some sort of a misrepresentation. But really what you're doing is you would be objecting to the accounting and saying that you're owed money because they sold the property for under fair market value.
Yeah. And what does the appraisal say? And who is the appraiser? Did you get your own appraisal? I mean, there's all kinds of issues that arise out of that issue.
Yeah, right.
Thanks, guys. That's all we had right now for questions that were pre-gathered. Encourage anyone to, if anything's on your mind, type it in the chat here. But anything else up with you guys this week, or anything come to mind?
You mentioned Heggstad, and I think it's interesting how, we have these terms that we understand, but if you're new to this area, you wouldn't understand. The new one that's going around that everybody's saying nowadays is Breslin orders. Everybody wants a Breslin order. Like, what's a Breslin order?
A Breslin order is an order for everybody to participate, or at least give notice to everybody to participate in a mediation in the case where you have multiple sets of beneficiaries, heirs, and it just basically puts everybody on notice. There is a mediation, and if you choose not to show up, that's your decision. But whatever happens to that mediation, if you then object to it later on at the court's going to ask you, why didn't you go to that mediation? Did you receive notice a Breslin order, notice the Breslin order? And if you receive that, the court pretty much isn't going to give you a voice in contradicting the settlement agreement that was reached by everybody else that showed up and put the hard work in to resolve the case.
And can the settlement agreement affect the rights or the share of the person who comes in later to object?
And that's the issue with Breslin. Yes. So if you have one beneficiary who gets 10% of the estate and they choose not to show up, and everybody else carves that 10% up for you, and it gets the case over the line to settlement, you may be screwed by that. So if you get a Breslin order, go to the mediation. You can appear by Zoom in most cases. You'll learn something, but if you get a Breslin order, you should go to the mediation.
Yeah, that's the shocking part. Like, you can literally lose your share. Like, nobody's thinking that.
Yeah, I think a judge would be somewhat sympathetic to a person that had their 10% carved up. If their 10% was left alone and they wanted more than their 10%, well, now the court's not going to listen to them.
Right.
But if their 10% is carved up, I mean, I could see a fair-minded judge saying, no, we're not going to do this. You guys need to go back and figure this out. But theoretically, the judge could say, you should have gone to the mediation. You didn't. All these people, I mean, think about the thousands and thousands of dollars it costs to go to a mediation.
Mm-hmm.
I mean, we're talking probably 50 grand if you have a bunch of beneficiaries and lawyers, and the cost for the mediator.
Oh, easy.
$50,000, $75,000 to go to this all-day effort. And by the way, a mediation usually starts around 9 or 10 in the morning. And we've been in the last 2 Fridays, and the first one went to 2 a.m. and the second one went to 1 a.m.
Yeah.
So, these things are hard fought, and everyone's working hard to get a settlement. And then somebody comes in at the last minute in court and says, oh, no, I don't want this settlement to go forward. And yes, I'm only getting a de minimis amount of the estate, but I still don't want it to go forward.
Yeah, we should We should have an episode dedicated to like mediation and the process and all that. But the mediation fee alone is 15 to 25,000 nowadays.
Yep.
And that's not including all what everybody's paying their lawyers to be there. Unbelievable.
Yeah.
Here's a good one that just came in. PH, thank you for joining us. They say, how would you know the difference between a standard will and a pour over will?
Ooh, I know. I've got this one. Okay. So, well, first of all, a will's a will. A will gives to beneficiaries, essentially. And so a pour over will is the easy way to think about that is it's a will that scoops up any assets that are outside of the decedent's trust. It scoops them up in a regular probate administration and just ultimately gives them to the trust. So it pours them over into the trust. Where a standard will would be one where I give my 3 kids, everything I own outside of, anything in my estate at my death goes to my 3 kids in equal shares. That would be a standard will. But a pour over will is just making the trust the beneficiary. And then the trust, all the terms in the trust are generally going to be giving down to in this case, the 3 kids that I talked about. They would give them in equal shares if they were all getting in equal shares. So that's the distinction between a standalone will. Keep in mind there's holographic wills. Those are handwritten wills by the decedent. They must be in the decedent's handwriting and signed. Ironically, they don't have to be dated. That just blows my mind. Or witnessed. But a good holographic will be dated in their handwriting, written in their handwriting, and signed in their handwriting. That is a very good holographic will. And then you have statutory form wills, right?
Yep.
And so you have those that you can look at as well.
That brings up, this was a comment on when we talked about video wills and that Montana Supreme Court case. This was what someone wrote in, and I wasn't sure about this, but they commented, so is it considered a holographic will and is thus not recognized in California?
It's not considered so if you do a video will or try to do a video will, it is not a holographic will, which is funny because when you think of a holograph, you're thinking of like Star Wars where the guy's like appearing. But no, it's not. So a holographic will by statute definition is a document that's written in the handwriting of the decedent. That's what is a holographic will. A video will not work in California because it's not signed and it's not witnessed.
And it's not in handwriting.
And it's not written in the handwriting. Or even if you want to do a formal will, it still has to be typewritten.
Yep.
So our code and our laws simply do not allow for video wills.
Or email wills. That's the other thing. If you send an email to somebody and you prove it that the only person that had access to this was the decedent, nobody else could have gotten it, it still does not suffice as a holographic will or any other type of will or any type of amendment to a trust. Unless I suppose in a trust, could you not have as the revocation or the amendment section, could you put that I can change this by email?
That'd be interesting. You might be able to, because it's not by. The difference with the trust is that you can vary the revocation amendment provisions in the trust itself.
Yeah.
So you probably could. Whereas with the will, that's by statute. You cannot vary that. It has to be done that way.
Yeah. I'm gonna have it where the person that wants to change my will, they have to actually run a triathlon. So they have to not only have a writing that's delivered to the trustee, but then they have to prove that they ran a triathlon with the will in their right hand
the whole time.
While
they're swimming,
yes,
bicycling.
Yes.
It's like the baton.
Yeah.
Yeah.
Right.
Well, cool. Yeah, I thought that was interesting because again, it is kind of counterintuitive. I was thinking holograph. I was thinking the Tupac holograph. Yeah.
Right. Exactly. That's a misnomer in that sense.
Well, cool. Yeah.
Did you want me to mention the book?
Yeah. Yeah.
So
but if you're watching the YouTube, you guys can look at the book.
So Stuart and I wrote a book. Well, we wrote 2 books, but this one, Your Lawsuit, was a book that we wrote to just walk people through the basics of a lawsuit. So if you want to know just how a lawsuit unfolds from the filing, discovery, mediation, it's not a long book, very readable. And you can just kind of get a really quick, nice summary overview of what a lawsuit is and how it works. So you can find the link to this on our website. Eric, you could probably link it on the description below.
Yep. Yeah. It's always in the video description.
And so something to check out. The other book, Stand, Fight, Win, that's a book that we wrote that talks about different fact scenarios that we encounter over and over again. We always say we only handle like 5 different cases because we have the same 5 fact scenarios over and over. And it's funny because we'll get a new case and the client will say, well, I bet you never heard anything like this before. Well, I mean, I probably heard it 5 times a day alone.
Right.
But yeah, so those are our 2 books. If you want to know more about kind of what we do and the inner workings, grab a copy.
They're available. If yeah, people want to leave comments in the video. We have a limited amount around here. I'll ship some out. So if you guys are interested, reach out
All right.
and I'll
Awesome.
get them to you. But awesome, great show, guys.
All right. We'll see you all next week.
Thanks, Eric.